Welcome everyone to our monthly webinar. This month, our topic is reasonable accommodations and specifically ensuring equal opportunity in rental assistance programs, a guide to reasonable accommodations. So why does this topic matter? First and foremost, providing reasonable accommodations isn't just a good thing to do, it's a legal requirement. I think we all know that by now. It's how we actively uphold the spirit and the letter of the foundational civil rights laws, such as the Fair Housing Act and Section 504 of the Rehabilitation Act. We'll get into those in a couple slides. Beyond the legal aspect, though, excuse me, this is about fairness. It's about ensuring that our housing programs are truly open to everyone in the state of Colorado who is eligible. Pardon me. By making simple changes to our policies, for example, we can remove barriers that would otherwise prevent people from getting or keeping a home in our rental assistance programs. It's a cornerstone of equitable housing access. But most importantly, the work that we do with reasonable accommodations has a profound impact on people's lives. When we approve an accommodation, it isn't just changing a rule or a policy, it's the key, oftentimes, that will unlock a person's ability to live independently in their community. And I'm speaking particularly, of course, of the Division of Housing Programs. It allows our folks not only to live independently, but fully participate in their community. And I'd like everyone to consider that last bullet, the statistic that 85% of the Division of Housing voucher households includes a person with a disability. It is our target population. It is where we pinpoint all our voucher resources to for the most part. And that means that the vast majority of the people that we serve in our voucher programs may be eligible to request a reasonable accommodation at some time during their housing participation to allow for equal opportunity to access the housing programs we offer here at the Division of Housing. So our global understanding, both as an internal agency and our external partners, and our ability to provide effective, reasonable accommodations is truly critical and central to the mission of the work that we do here at the Division of Housing. Let's start with the really fun stuff, the legal framework. There are a couple different foundational civil rights legislation pieces that really guide the work that we do with our programs and with specifically reasonable accommodations. So to begin, we have the Section 4 of the Rehabilitation Act of 1973. This is the single most important piece of civil rights legislation for people with disabilities. It was the first law in the United States that protects people with disabilities from discrimination in 1973. And I know many of us were around for 1973. So it feels still fairly like new legislation. Its basic premise is that if an organization, such as the Division of Housing, receives federal funding, that organization cannot discriminate against someone because they have a disability. It's the foundation of equal access to individuals. So if Section 4 laid the groundwork for equal access, then the Fair Housing Act of 1968, and particularly the 1988 amendments, sort of completes the puzzle. The 1988 amendments were a game changer because they added disability as a protected class, and it expanded the protections to a much wider range of housing. So while Section 4 applies to those federally funded housing programs and other federally funded programs, not just housing, the Fair Housing Act is much broader, and it applies to virtually all housing in the United States, whether it's public, private, or receiving federal funds. And particularly the amendment in the Fair Housing Act that applies to the work we do makes it unlawful to refuse reasonable accommodations in rules, policies, practices, or services that are necessary for equal housing opportunity. And then it prohibits agencies to or anyone to refuse reasonable modifications and failing to design accessible housing for individuals with disabilities. So these are the two foundational pieces of legislation, as the slide says, that informs the work that we at the Division of Housing and all housing authorities do in relation to reasonable accommodations. Let's talk a little bit about the definitions of reasonable accommodation. You'll see we've offered the definitions that are outlined in both Section 504 of the Rehabilitation Act and the Fair Housing Act. Without reading through this slide, because I know you all have the ability to read that, and I will be sending the handouts following this presentation, I've highlighted and underlined the important words that you see here. And they're the same, right, in both the definitions for both pieces of legislation. It's ultimately a necessary change that an agency can make to allow equal opportunity for individuals with disabilities to participate or benefit from a program. So again, very important, both pieces of legislation highlight that definition, and we as a recipient of federal funds must adhere to this. So just providing the key definition so you can see what is expected of us as a housing authority. Oh, interesting. Sorry about that transition. We also have a definition for person with a disability. In both Section 504 of the Rehabilitation Act and the Fair Housing Act, this definition is similar. A person who has a physical or mental impairment that substantially limits one or more major life activities. If a person has a record of such impairment, or if a person is regarded as having such an impairment. So it's a rather broad definition, and we'll get into a little bit about how we verify that, but that is the definition in respect to someone who would be eligible to request a reasonable accommodation. When we're talking about the definition of disability in terms of getting the disability allowance, for example, in the voucher programs, that's more in line with the Social Security Administration's definition of disability, which is a little more, not the word isn't strict, it's a little more intense. And so you have to meet a couple more check boxes on a form, for example. But in terms of requesting a reasonable accommodation, there is a little bit more flexibility with that definition. An important note on the slide is that to ensure equity and equal opportunity, treating people with disabilities differently through a reasonable accommodation is not only allowed, but it's required. We'll talk a little bit too about some of the pushback that we hear when we advocate for our participants to receive a reasonable accommodation. I think we often hear, well, it's not fair housing if I'm not offering this to everyone. But in fact, it is. It is spelled out in the Fair Housing Act that you must offer a change or something different to a person with a disability so that they can have equitable access. And just working on our language and how we can advocate for our folks, I think that's an important distinction that we need to point out. So those of you who've seen this before know I really do like this graphic. When we hear the question, shouldn't we treat everyone equally? Sure, we should treat everyone equally, but let's look at what that could possibly look like. This image illustrates why treating everyone equally isn't always enough and why reasonable accommodations, especially in our programs, are crucial. So I'll try and break it down. If we look at the top left panel, inequality, here we see two individuals both trying to pick apples or to get apples. You'll see that the tree is leaning in favor to one person and not the other. The person on the left has better opportunity to access the apples because the tree's leaning in their direction. So this is going to represent the starting point where there's just unequal access to opportunities in some cases due to differences or systemic barriers. Not everyone is going to begin from the same place. Some are going to face disadvantages that will prevent them from accessing the same resource. So let's move on to the top right panel where we have equality in this graphic. So in the panel, both individuals are given the exact same tool, equality. They are both given the same size ladder. But what you're going to see, it looks fair on the surface, right? They have the same tool. But you'll notice that the person on the right still cannot access the apple, even though they have a ladder, just like the other person. The other person, however, now has easier access to the resource, to the apple. This is equality, providing everyone with the same resources or giving everyone the same treatment in a program. But as you can see, it doesn't always lead to that equal outcome that we were hoping for, because it doesn't account for something that's different, a person having different needs, or somebody starting from a different vantage point in life. In the context of our programs at the Division of Housing, this would be like having a blanket policy that applies to everyone, regardless. And then we're not considering, though, how it might be a disadvantage to someone with a disability. So again, highlighting the importance of offering reasonable accommodations in our program. If we jump down to the bottom left panel, equity, here you're going to see that the individuals are now given a custom tool based on their needs. The person on the right has a taller ladder. Now they can finally reach the apples. The person on the left didn't need quite as tall of a ladder to get that same benefit. This is the definition of equity, providing resources or support that's going to be tailored to an individual based on their needs to address the existing inequalities that they might be experiencing. This ensures everyone has a fair chance to succeed or fair access to the resources that we offer. And this is a good, this is where reasonable accommodations are going to come into play, right? The different tailored ladders. So not everyone's going to need the same policy change or accommodation. We have to tailor it to the specific person's need. Making it necessary adjustments to policies or practices so that a person with a disability can have equal opportunity, just like everyone else in the program. Again, we're not giving someone an unfair advantage here. We're just tailoring the tools to even the playing field. The bottom right panel, justice, this is our ideal world. We're going to go a step further. Instead of just giving different custom tools, different size ladders, we're going to fix the system that's broken in the first place, right? The tree, we're going to repair it so it's not leaning to one side. So it's straight and everyone has that equal access to the resource. It represents fixing the issues that created inequality in the first place. So in housing, an example, not necessarily in our programs, but when you think of universal design principles in new construction. So rather than just making a couple units accessible for people with mobility impairments or some other disability that requires an accessible unit, just make every unit universal, designed universally so that everyone can equally access the unit. To summarize, equality aims for sameness, equity aims for fairness. Offering reasonable accommodations is a key component to achieving equity, which is what we are trying to accomplish here in our program. And I'm hoping that this graphic, despite my stumble on some of the pictures, makes sense. But I think it's a really good graphic to express what we're trying to talk about here with reasonable accommodations. So I want to talk a little bit about some key statistics, again, on why we're doing the work that we do here. To begin, let's understand the scale of disability in our state, in Colorado. So according to recent census data, approximately 11% of all Colorado residents have a disability. That's a pretty significant portion of our community. So again, I think it highlights the importance of the programs that we provide here at the Colorado Division of Housing and targeting our housing resources to people with disabilities. If we look at the national statistic within the Housing Choice Voucher Program, we can see that people with disabilities are served at a higher rate than the general population. So nationally, 26% of all HCV households include a person with a disability. In Colorado, that trend is a little bit more pronounced, with 31% of Housing Choice Voucher households, including a person with a disability. So this highlights that our housing assistance programs are a crucial resource for this population. Now let's look at our own programs here at the Division of Housing. The number is even higher, an astounding 85% of our voucher households within the Division of Housing voucher programs include a person with a disability. This underscores the fact that our program is truly a lifeline for people with disabilities. And it's just a reminder that our policies and procedures around reasonable accommodations are really central to the work that we do. And then another statistic that I didn't put up on the screen, but just sort of highlights the work that you are all doing in the field, and then the work that our internal team is doing. On average, the Division of Housing receives, reviews, and responds to approximately 1,400 reasonable accommodation requests each year within our housing voucher programs, the majority of which are approved. And so the work is important, the work is critical. A large portion of our participants are requesting accommodations at any point in their housing participation. And so again, just really highlighting why it's important we understand this requirement, because it really does impact a large portion of our participants. So on this slide, we are just summarizing the very common reasonable accommodation requests that we see come into to you at the partner agency, and then oftentimes, not oftentimes, every time to us here at the Division of Housing. We'll talk about process in a couple slides. But just, briefly, live-in aids, requests for an additional bedroom for medical equipment, requests to rent from a relative, exception payment standards, exception utility allowances, voucher extensions, probably the most frequent one. We receive our voucher extension requests to participate in a shared housing situation. And then just to highlight a couple common requests that our landlords will potentially receive, and that's requests for an assigned parking space, or possibly waiving the no pets policy for a service or companion animal. Again, we don't really tackle those bottom two, but you probably often hear from your participants about those requests. So just understanding what we're hearing from landlords, as well as the common requests that they're receiving. So we're going to go into a couple specific examples of these requests, and just give you a quick overview of what we're looking at. So for live-in aids, we must allow for elderly, near elderly, or disabled persons who need supportive services. We have to honor that they potentially need a live-in aid. The definition of a live-in aid, however, is someone who is not legally obligated to support the person, think a parent or a guardian, and would not be living in the unit except to provide the necessary services, think a spouse, a partner, etc. So it's somebody who isn't in the unit already in a supportive relationship with this person, either as a parent, a partner. They need somebody to come into their unit to assist them with their daily life. And then the live-in aid must be using the subsidized unit as their only residence. It cannot be someone who simply comes in every day to help the person and then goes home at the end of the day. This is defined in regulation. And this is also a very common request that we receive. I think where folks might be seeing this request being denied is if somebody is requesting that their spouse, for example, be the live-in aid, or they are a parent for a young child and the young child needs a live-in aid and the parent is saying, I'm the live-in aid. Those are the situations where we have to deny just based on what's in regulation. We also receive requests for additional space for medical or exercise equipment. Another common one that we do receive is requests for exception payment standards. This is a request for a higher payment standard to allow a person with a disability who may be having difficult finding suitable housing within the current payment standards of the housing authority. It will allow them to have a higher payment standard so they can access a higher cost unit. So for example, first floor units tend to rent at a higher rate. And folks with mobility impairments may require a first floor unit to avoid the need for stairs. So we tend to see, hey, this unit, costs a little more, but it's on the first floor. Could we get a higher payment standard in that case? We have very specific process, forms, and documentation in order to request an exception payment standard. I believe we do have an action alert that spells this out on our website. We ask for this because if the request for an exception payment standard exceeds 120% of the published fair market rent, we have to then submit that request directly to HUD headquarters in DC and ask for them to approve the exception payment standard. And they have very stringent requests for documentation. So if we can collect all that documentation up front, it allows for a quicker turnaround time at the DC level, should we have to request it beyond our level of approval. Another common one we see with our population is a request to rent from a relative. This is an exception to the HUD regulations, which prohibits renting from relatives. We can grant it as a reasonable accommodation for a person with a disability. One thing we have to make sure we are doing is verifying that that relative or the owner of the unit does not also reside in the subsidized unit. So while the rules state you cannot rent from a relative, we're able to accommodate that for people with disabilities. What we are not able to accommodate is the HUD regulation that the resident owner, that it is not a resident owner, meaning that the owner of the unit does not also reside in the unit. That is not something we are able to accommodate, just to offer a little clarity. Again, there are certain instances where if it is a HUD regulation, a must versus a may, the request to accommodate that regulation to change that policy needs to go directly to HUD. It is not something that the Housing Authority has the ability to accommodate. So just kind of keeping that in mind. And again, we are happy to bridge that with the HUD office to get those requests to the right place in those instances where we need to do that. And then, as I mentioned, one of the most common requests that we get is a request for voucher extensions. This is available for households that include a person with a disability who are experiencing difficulty finding suitable housing on their searching voucher or their newly issued voucher. So the vouchers are good, right, for 120 days. If we're coming upon that 120 days and our participants have not been able to use the voucher, and it's a disability related reason, they can do an initial request, which is just like all of the other reasonable accommodation requests. It comes in on our form. Ideally, of course, they can request it in any way that works for them, but ideally it will come in on the form, stating the reason why, the connection or the nexus between their disability and why they're having challenges utilizing their voucher. Should that be approved, they do not need to complete that whole paperwork packet again each time. So their voucher will be extended if they come upon that extension coming to an end and they need to continue to search. They can just simply request another extension. They don't have to go through the whole reasonable accommodation process once they've done that initially. This allows us to quickly approve it and allow us to extend the voucher in Elite, so the folks can still continue to search. I think you'll see oftentimes this can go on for quite a while, but there will be a point in the extension timeline where we do look at it case by case and ask for another full paperwork packet to come back in, detailing again why these continued extensions have not been successful. So those were some of our most frequently received requests, which, as I mentioned earlier, of the approximate 1,400 requests we receive every year, and most of which are approved. I don't have that percentage off the top of my head, but more than half, more than 75%, in fact, of those requests are approved. There are cases where a request is denied. And the regulations stipulate what valid reasons there are to deny a request for reasonable accommodation. So first and foremost, if the request was not submitted by or on behalf of a person with a disability, that is a valid reason for a denial. A person requesting a reasonable accommodation must have a disability as defined in that slide, that earlier slide, where we shared what the definition of disability was, according to Section 504 in the Fair Housing Act. Additionally, if there's no disability-related need or nexus, and that's a connection between the disability and what is being requested, the requested accommodation, it can be denied. So if a person is stating, oh, I hate to do these on the spot examples, but I'm a person I'm a person with, oh my gosh, I'm not even going to do it because I'm going to mess it up. So perhaps Lynn or Fonda, you can put an example in the Q&A and I can read it. But we really need to see what their disability is, if it's not apparent, and what they are asking for. Doesn't make sense. Is this going to offer them equal access? Sometimes we see sort of off the wall requests that don't necessarily connect, just requires a little additional conversation oftentimes. And then we can deny if the accommodation is not reasonable, quote unquote reasonable, because, and this is in regulation, it imposes an undue financial and administrative burden to the housing agency, or it causes a fundamental alteration to the nature of the program. So again, I'm kind of circling back to what I mentioned just a couple minutes ago. If an accommodation is believed to be unreasonable, or we're not seeing the nexus between the individual's disability and what they are requesting, we would proceed with what's called an interactive dialogue. We'll talk about that in a couple slides to discuss either to try and understand the connection between what they're requesting, or possibly to discuss some alternatives to what the accommodation they're asking for. So let's break down a little bit those reasons for denial. And Shauna, I think this will touch on your question a little bit in the chat or in the Q&A. So first and foremost, housing agencies are able to deny a request for reasonable accommodation if it causes an undue financial or administrative burden. Defined, that is an action that requires significant difficulty or expense to the housing authority. Housing agencies are asked to balance the burden on the housing agency with the benefit to the resident. That's subjective, but we often have to do this based on the large amounts of requests that come in. We know what that balance looks like. Some of the factors we consider is the cost of the accommodation to the housing authority. A look at our financial resources that we have available as an agency, and the administrative responsibilities it might cause. So Shauna, your question about is the housing authority, let me jump over to it again. How likely is the Division of Housing going to be to approve a higher payment standard? One of our previous slides showed exception payment standards. That's requests for a higher payment standard. We do see this quite a bit. And when we talk about undue financial burden, we're talking right now, the Division of Housing is in a HUD identified budget shortfall. We ended 2024 in a budget shortfall. We are currently identified to end 2025 in a budget shortfall. We have documentation from HUD that specifically outlines the things we need to do as a housing authority for the next several months to get us to the end of the year in order to limit that shortfall as much as possible. Should we follow their guidance and do those things, we are eligible to receive set-aside funds to help us end the year not in a budget shortfall. But part of that is looking at our financial resources. Do we have reserves available to approve a higher payment standard? Are we in a budget shortfall? So when we are still looking at every request that comes in. Every request is reviewed on a case-by-case basis. If there is one that we can't afford, for lack of a better term, because of our current proposed projected budget shortfall, we have the responsibility as the recipient of federal funds to make sure we are not overspending our federal funds. by actions that are deemed, within our control. So what you may be seeing right now is some pushback on some of the requests that are coming in, just because we don't have the dollars this year to afford it and end the year with our ability to continue to house everyone on the program. So it's not a yes or no. There are always requests that come in that we see as absolute requirement on our part to say yes to, because again, the Section 504 of the Rehabilitation Act and the Fair Housing Act are the ultimate determinants of what we can and cannot approve. Our budget is secondary, but there is a point where we will have to come back and say, here's an alternative. Again, you asked for this, we can offer this instead, which we believe would give you a similar outcome. Another reason for denial is a fundamental program alteration. So this is a change that's so contrary to the rule's purpose that it becomes unreasonable. Our, typical example that we like to share, and these are true examples that have come into the Division of Housing, we think really highlight what a fundamental program alteration is a request from a participant for the housing authority to soundproof their apartment because of a mental health diagnosis, right? The Division of Housing we don't provide that type of construction or improvements to an apartment. So that is a fundamental alteration to the work that we do. Or a request to a landlord that maintenance staff come to their unit every day to take their trash out to the dumpster. They're not able to get the trash down to the dumpster for disability related reason, but their maintenance staff's only on site twice a week. So they could essentially deny that request to say the alternative is twice a week when our maintenance staff are on site, they will come and take your trash to the dumpster. That's a fair denial. And then that's an example of an alternative that we are offering. Okay. So let's get into the Division of Housing process, how we handle requests for reasonable accommodations, starting at your partner agency, and then moving on through the process to the Division of Housing. So of course, you are all receiving this request for an accommodation. Generally speaking, you're receiving the request first. Sometimes they come into us and then we forward them on to you all, but that process starts with you. We ask that regardless of the request, and I do think we touch on this a little bit, that you aren't discouraging somebody from making a request. You can always help them understand what they're asking for, how to fill out the forms, but at no point should anybody in the process, either at the partner agency or at the Division of Housing, discourage a participant from requesting an accommodation or telling a participant that would never be approved, don't even bother. It's important that every participant has the opportunity to make the request. So when we're looking at requests for accommodations, we're going to start with disability. Do they meet that definition of disability? If the disability is obvious or known, we're not going to request further verification. If that is apparent. So very basic. I am a person who is in a wheelchair. I need a first floor unit, or I need a parking spot that is close, to the building. We don't need doctor's verification. We don't need to see that. It's very apparent to us what this person is requesting makes sense with the disability that is being presented to us. That's the easiest, best case scenario, right? If it's a very obvious or known disability and the request makes sense, we don't need to go through the hoops. But more times than not, it's often a non-obvious or an unknown disability. In those cases, the family must request the reasonable accommodation. So the first step is your determination at the agency level. Does this person meet the definition of a person with a disability? They're receiving Social Security payments. That verification is done automatically. We don't even need to go a step further, right? Social Security Administration has deemed this person to be a person with a disability, case closed. We don't have to see anymore. If they are not receiving those benefits, though, we do have a verification of disability form that may be helpful on our website to provide to a knowledgeable professional, a knowledgeable medical professional that can make that determination that they meet the definition that is spelled out on that form. Or if a medical professional just writes something, this person is a person with a disability, right? We're not gonna pick that apart. The key component here is that they are a knowledgeable medical professional who can make the determination that a person is a person with a disability that meets that specific definition of person with a disability. And then the accommodation, again, must enhance the family's access to program or services. Not your decision at the agency level, but we want to see those the accommodation request form kind of filled out. Like, this is the disability that I am presenting with, and this is the accommodation that I need. And that's having a clear connection there helps this process go quicker on our end. So that request for reasonable accommodation, once we have the verification that the person is a person with a disability, this request should be completed by the participant, and then there is a document that will be completed by a knowledgeable professional that the family identifies, who can make the determination that yes, this person needs this accommodation. A knowledgeable professional who works with this person in some capacity, can state that yes, because of their disability, they do need this accommodation. We are really only asking for pertinent information related to the disability related accommodation need. We don't want to see medical records, okay? We don't want to know necessarily specific diagnoses. We don't want to see their treatment that has been given to them. This is very confidential information that should in no instance be kept in the file. If something needs to be in the file, we need the very specific information to be redacted. We can see it oftentimes if there's a lot of specific medical record diagnosis information, etc. We may need to see that to make our initial approval, but we don't want that to stay in the file. It's just too much confidential information that could potentially be exposed. And so just to make a note, please do not continue to keep all that stuff in the file. We know our families want to show us exactly what they are requesting, and we appreciate that. What we don't want is to have a HIPAA non-compliant file floating around out there. So again, let's talk about that process flow. The participant will, approach the agency or their housing coordinator and submit that request for a reasonable accommodation form that they were provided. They're also going to be given that verification of need for a reasonable accommodation form that the knowledgeable professional will complete. These are the things we ask for our participants to do. As always, and I say this again and again, it doesn't have to come in on our very specific forms. The very specific forms are helpful. They outline exactly what we need to make our determination. But if that's not the format that our participants are able to submit the request on, we can be flexible with that. It is very helpful in speeding up the process to see the information on these forms. At your agency then, once you receive the documentation, the request, the supportive paperwork from the participant, you're going to send that on to your SPOC. Of course, we ask that you review it with the participant, make sure they've signed everything was complete, so that we're receiving complete paperwork on our end, but not to discourage them from submitting it. If you see something like, hey, maybe you might want to consider saying this instead, it might help the process go a little quicker. By all means, please provide them with that technical assistance. But we really want our participants telling us what they need and getting it to the Division of Housing for review. Our SPOCs here at the Division of Housing do that initial review to make sure that the request complies with HUD regulations and the Division of Housing policy. They may request additional documentation from you if paperwork is missing or there's just something that we need to see in addition. But generally, if everything is there and there is a nexus and the request makes sense, our SPOCs are able to do that approval. And they notify you at the housing agency that the request has been approved, and we ask that you in turn notify the participant that their request has been approved. In those rare cases where a request is denied, our SPOCs will, they don't make that determination here and just at that point. If there is a request that our staff believe, I'm not sure this could be approved, they will submit it to our reasonable accommodation panel. We have a panel of 3 staff who meet once a week, look at all of the requests that come in that cannot be approved at face value, right? There's just something that's not clicking with that request. And so our panel, our 3 same consistent panel, is going to look at all of those requests together and come up with a consistent determination on whether something can be approved as is, needs more paperwork, needs an interactive dialogue because we're just not seeing everything we need to see, and then in some cases, then a final denial. That all happens at the panel level. In those cases where something is denied, the Division of Housing will send a letter to the participant directly, and we will make sure that the housing agency is copied on that letter. And then any sort of decision we have made on requests that come in is documented in the Elite Hot List. Oh, fingers crossed. Yes, the next slide shows the Elite Hot List. So if you're looking on that first page in Elite, the resident information page, you will see what's called the hot list. Sometimes it's blank because perhaps the person you're looking at has never requested a reasonable accommodation. But what you will see if they have is just every time a reasonable accommodation request comes in, we are documenting that in the hot list with the title of what it is. It's a reasonable accommodation request. And then we are putting in yes or no, yes meaning it was approved, no meaning it was denied, and the year of that request. So in this specific instance, you'll see this person has had a request every year for something that has been approved. You as an agency can double click on each of those indicators to open up the hot list to see the details of what was requested, what was approved, and so on. Very helpful information, particularly as you are working on annuals and you see someone may have a continued need. Again, something we'll discuss in a couple slides. Something we will discuss in the next slide. For our folks who have an approved accommodation, you will see in the hot list, yes, they have an approved accommodation. As you are working on their annual re-exam, you may wonder, does this person continue to need this accommodation for an exception payment standard in the current unit that they're staying in, for an extra bedroom for medical equipment in the unit that they are just renewing their lease in, for higher utility allowance because they have a lot of medical equipment that they need to run in their unit that causes their electricity to be higher than an average, utility bill would necessitate. If they have an accommodation that needs to be continued through their next annual re-exam, we have one form called the verification of continued need. We're not asking our families to go through that whole process of requesting the accommodation, of getting the documentation completed by the knowledgeable professional. We are just simply asking them to declare, I still need this accommodation, so that we can continue to track the accommodations that we have active on any given day. Again, documentation from a knowledgeable professional is not required annually. The only exception to this is that if a participant moves and the accommodation we approved was tied to the specific unit they were in, for example, they requested an exception payment standard for this very specific unit that met their disability needs, they are not automatically approved for that exception payment standard in the new unit. It's possible they may need to go through and complete the full request for an accommodation again. once in a case where the accommodation was linked to their unit. So let's talk about denials. Again, we did talk a little bit about the reasons why we can deny. But this is, and again, the Division of Housing is the only agency that's going to be denying reasonable accommodations. So if the disability or the need for the requested accommodation isn't obvious, again, there isn't that obvious nexus, the housing authority must initiate an interactive process with the person. This is an interactive process is like a good faith discussion or a good faith dialogue for us to better understand. And when I say dialogue, this could also happen via email, right? It's not necessarily a sit down. But it's just allowing us to understand that connection or that nexus between their disability and the requested accommodation that they are asking for. And during this process, the housing authority might suggest an alternative accommodation that could meet their needs without creating that undue burden for the agency. So a common example is a participant is in a 2-bedroom unit and their adult child has left the unit. They are told you are now only eligible for a 1-bedroom unit. We would suggest finding 1-bedroom unit, or you can stay and pay this higher amount. We are seeing an increase of that participant submitting a request for 2 bedrooms now. I need 2 bedrooms. This is costly. And not always we are seeing the reason why. We are not seeing a clear nexus of why they need that additional bedroom specifically. They may say, I need more space for X, I need more space for Y, I need more space for Z. If we cannot make that connection of why a whole additional bedroom would be the appropriate accommodation, we may offer an alternative of a higher or an exception payment standard for the 1-bedroom payment standard, right? Rather than give you 2 full bedrooms, which, the request may not really be connecting on why they need that full 2nd bedroom, we can offer the alternative. We do see you need more space. It doesn't appear that a 2nd bedroom is the correct accommodation. What we can do is offer you a higher payment standard for the 1-bedroom. So that's that interactive discussion, providing alternatives, understanding, maybe we're not understanding your need for a 2nd bedroom. We might need a little bit more documentation from the knowledgeable professional outlining all of the pieces of equipment that you need. We're not seeing it in what you've provided. So really just keying into that discussion, not just saying no, right away. We want to get a little bit more information. If the nexus cannot be established after that process, or if the alternative accommodation is denied or not accepted by the family, the request is effectively denied. So if the person agrees or disagrees with that denial, which they tend to, they do have a right to file a grievance with the housing authority. And then just a reminder that our failure as a housing authority to provide necessary accommodations that are truly needed, that are documented, and then should we still deny them, that could lead to investigations and potential fines. So, again, highlighting the need to have a very clear process for how we review our reasonable accommodations. And just, again, also highlighting the need for everyone who works in our programs to understand the importance of this process. So the Division of Housing, sort of repeating myself here, but I think it's really important. We do have that formal procedure to review reasonable accommodation requests to ensure that we are employing a fair and consistent process as we review particularly the requests that cannot be approved as is. So if a request is ultimately denied, the Division of Housing program manager, one of the program managers, will send the denial letter directly to the participant within 10 business days. And again, we're going to copy you all on that letter. And just a reminder, not just in requests, the reasonable accommodation process is offered at any time in somebody's participation in the housing program. So all of our applicants and participants are informed of their right to request a reasonable accommodation at the time of their briefing. For example, there's a section in our packet that really goes over that process and provides the forms. The information is provided not only during the briefing, but in any adverse action that we might take and notify our participants about. Think a termination, think a negative or a denial of something in the program. We have a statement that says if you are a person with a disability and you require an accommodation to, fully access our program, please see this attached paperwork. And then all of our termination letters, for example, that are sent out include information on how a participant can request a reasonable accommodation. Our participants and applicants that have a disability can request an accommodation at any stage of their housing assistance. Our policies here at the Division of Housing are flexible. And again, we must accept the requests for accommodations in various forms, not just the formal paperwork that we have provided. Again, that's so helpful because it has everything that we need in it, but we understand that that's not always the ideal way for some folks to request accommodations. So should a participant file a grievance or a complaint in response to a denial of a reasonable accommodation, we don't want to scare, but we just want to inform everyone who can be named in one of these complaints. An agency can be named. So for example, the Division of Housing can be named in the complaint, the landlord can be named in the complaint, our partners can be named in the complaint. And then in addition, individuals can be named. And I say this because I've been named many times, like my own personal name. So Division of Housing staff can be individually named in the complaint, and you all at the partner agency can. Our hope is that taking this off of you, not giving our agencies the opportunity to approve or deny accommodations, it's not a reflection on what we believe you can and cannot do. It's to divert all responsibility to ultimately the Division of Housing. It is our program, it is our determination. And so should there be a denial, an adverse action of some sort, the goal is it's not coming from you all as our partners, to sort of keep you from being named in these, specifically about denying reasonable accommodations. You shouldn't be named in those because it's not your denial. Now, if you're discouraging people from requesting it, that's a different story. Again, we really want to hit home that all requests should come into the Division of Housing. So there we go, I said it. All reasonable accommodation requests should be sent directly to your SPOC. What we do ask is that you ensure the requests are complete with all necessary information and documentation included. It just helps speed up the process. We don't have to have that back and forth continuing to ask for things that might be missing. Participants can always request an accommodation. They should not be discouraged. And only a DOH program manager can deny a request for accommodation. No other entity should be denying these requests. And this is, again, so we can be consistent in how we apply wow, we're just consistent in how we are reviewing and responding to requests, and then as always to just sort of protect our staff and our partners from those negative potential implications of a civil rights complaint. In the handout that I'm going to be sending you all, I have made all of these resources clickable. So once you get that PDF from me, you will be able to click on these rather than me typing out the whole web address like the old-timey days. But we do have resources we like to share with you all. We have our reasonable accommodation forms and packets on the website. Again, not the required, they don't have to be on these forms, but these are very helpful. We do have like a 15-minute little short on the reasonable accommodation process. It's hosted on YouTube. That might be helpful if you don't have time to sit through, an hour-long webinar. That might be a helpful just how-to in completing the reasonable accommodation paperwork. We refer you to Chapter 2 of our administrative plan that talks specifically about fair housing and equal opportunity. And then just a handful of other important federal resources. We've got the HUD DOJ joint statement on reasonable accommodations. It's old, I think. Not, and when I say old, I mean 2014. That's not that old. But it's really good information on the expectations at the federal level about reasonable accommodations. We have a couple different HUD federal regulations here that kind of outline our responsibilities as a federally funded program. And then there's a really good one that defines who can be a live-in aid. Bazelon, of course, if you're not familiar, has some really good information on emotional support animals. Not our specialty here at the Division of Housing, but certainly a question we get a lot. So we want to share that with you all if it's helpful to be able to provide some advocacy for your participants. They also have a great one, What Fair Housing Means for People with Disabilities. And then this is a really good link down here, a guide just to all the different disability rights and laws that are available right now. Fair housing in Section 504, of course, being the two that we highlighted here, but there's the Americans with Disabilities Act, along with several other good resources on that page. That is all we have. I'm going to stop recording, but then would like to take time for questions.